Hey, nurse practitioner and attorney Nick Webb here, and today I'd like to talk to you about misclassifying your employees as independent contractors. Now, at first blush, this might not seem like a big deal, but from both a state perspective and from a federal government perspective, it can be a huge deal if you misclassify your employees, whether they're clinical or otherwise, as independent contractors when they're really supposed to be W-2 employees. There's three things that I want to talk to you about in my video today. First, why an employer might choose to make an employee or classify them as a 1099, whether that's right or wrong. Also, too, we're going to talk about some things in terms of California state law, in terms of AB5, which has been around for a couple years. We'll talk a little bit about SSH determinations by the IRS, and then why it's better to do a corp-to-corp contract or W-2 as opposed to misclassifying a nurse or a nurse practitioner individually as a 1099. So let's start. First and foremost, why might an employer choose to misclassify or classify a nurse or nurse practitioner as a 1099 versus a W-2 employee? Well, the big thing is that employers oftentimes want to save on the Social Security and Medicare tax, which they're obligated to pay half of. And so they have to pay half of that 15.3% that's paid to the federal government so that you can get your Medicare and Social Security taken care of when you're older. In addition to that, if you are classified as a 1099 contractor or independent contractor by your employer, typically your employer doesn't have to pay any unemployment insurance, and they also don't have to pay any workers' comp insurance. So if you are injured on the job, let's say that you're working 40 hours plus a week, but you're classified as a 1099 contractor and you're injured or you have to be out, you're not going to be able to claim unemployment insurance benefits or workers' comp benefits. So this can be a really big deal. Now, in California, for most, almost all, but definitely most, nurse practitioners, RNs, and even physician's assistants, also LVNs in California too, since the passage of AB5, most are not classified as independent contractors. And as a matter of fact, probably 99.99% of the time, RNs, NPs, LVNs, and PAs, with the exception of physicians who were specifically exempted under Assembly Bill 5, they cannot be classified as 1099 contractors. They either have to be paid under their own professional corporation, right? If they have their own professional medical corporation that they share with a physician as a 49% shareholder, or their own professional nursing corporation, or they have to be paid as regular statutory W-2 employees. And obviously, we talked about some of the reasons that employers might like to hire folks as contractors because, again, they want to avoid paying some of those traditional payroll deductions either to the state or to the federal government. And so again, the reason that we're doing this video is if you are an employer who employs nurses or nurse practitioners or LVNs or PAs, it's really important that you not misclassify these folks as independent contractors and pay them in their own name. Either require them to form their own professional corporation so you can do a corp-to-corp contract and then their corporation can hire them as an employee, or hire them as regular W-2 employees. Failure to do that can result in huge settlements and verdicts, particularly in California and other states that are a little bit more progressive or left-leaning.